So welcome everybody. Welcome to Landmark Chambers and Womble Bond Dickinson's joint webinar on what's happening in environmental law in the UK from the end of this calendar year. So we're delighted to see so many of you joining the session today, especially with the temptation of the weather outside. So thank you for joining. And we do hope that you will find the presentations and discussion to be useful and informative. So my name is Claire Brook. I'm a partner at Womble Bond Dickinson and I head up our real estate practice. I also specialise in planning and environmental law, so I shall be listening with interest as well. So I'm delighted to have been asked to chair the session today, and I'm joined by Landmark Chambers David Elvin QC and James Maurici QC, as well as my colleagues Stuart Wardlaw, who's a partner, and Sarah Holmes, a legal director, whom I'll come back to formally introduce in a moment. But just before I do that, a few housekeeping points for everybody to note. So your microphones are automatically muted, so you don't need to adjust your local settings. We very much welcome questions throughout the session, and you'll see that there is an ability to submit those via text in the Q&A section, which may be found at the top or bottom of your screen. We'll endeavour to answer as many questions as possible in the time available at the end of the presentations in a separate session. So also just to confirm that this webinar will be recorded, and you will also receive a link to the presentation and the recording shortly after the event concludes. So if at any time you do lose connection, then we invite you to rejoin the meeting by clicking on the original link again, so no problem to do that. And then finally on housekeeping, we will also have a short comfort break for 5 minutes after the second presentations by James. Okay, so let's get started. So what's happening in environmental law in the UK from the 31st of December this year? As we all know, the UK left the European Union on the 31st of January this year, and the government has insisted that there will be no extension to that transition period. So although a huge amount of attention has been diverted as a consequence of COVID-19 from preparing for the end of that transition period and our future relationship between the UK and the EU, the terms of the withdrawal agreement, the laws of the single market, and the emerging legislation from Westminster in terms of how that also impacts devolved administrations are now becoming a certainty. So from the end of this year, the UK will cease to have its own single internal market. It will no longer be subject to the common overarching framework of EU environmental law, the so-called level playing field, or operate within the regulatory regimes of the single market. So what will fill these spaces? So we've identified some key areas to focus in on today that will affect all businesses and organisations, and we'll be looking at what we know will happen, what might happen, and how you can prepare for that. So just before we get into the topics themselves, just to go back and introduce my 4 colleagues. Our first speaker, David Elvin QC, practices in England, Wales and Northern Ireland. He's practiced in the areas of environment planning, local government and public law for over 35 years now, and he acts for a variety of clients, from private clients, regulators, central government, including Northern Ireland, and has also appeared in many leading cases. To name a couple, the recent Supreme Court case for TfL and Southwark, and also the Dill versus Secretary of State case as well. He's been a Deputy High Court judge since 2008, mainly sitting in the admin and planning courts, a Crown Court recorder and a member of UTIAC. He was one of the Parliamentary Boundary Commissioners for England for 10 years to 2019, and he's also one of the general editors of the Planning Encyclopedia. He's currently practicing, like many of us, from his study, but on the North Downs in Kent, accompanied, he tells me, by his 2 Labradors and a great deal of wildlife. So David's going to kick off the first topic, and he will be giving us an update on the Environment Bill, looking in particular at the overriding objectives of the bill the environmental principles and the role of the new body, the Office for Environmental Protection. But before I hand over to David, just a quick intro on the three remaining speakers. So James Maurici QC, called to the bar in England and Wales in '96. He was appointed Queen's Counsel in 2013, and he also practices in planning, environmental law and public law, and regularly deals with EU and international law aspects as well. He acted as lead counsel for the Department of Transport in the recent Heathrow expansion litigation, in the Divisional Court and the Court of Appeal. He's made many appearances before the Court of Justice of the European Union and the General Court of European Union as well, formerly the Court of First Instance, in a number of environmental cases covering waste, environmental information, EIA and emissions trading. He also has appeared a number of times before the Our House Compliance Committee in Geneva. He's currently acting for the UK government on the Brexit communication to the Compliance Committee. James, with his subject, will be looking at the potential for further divergence in environmental law in the UK and specific devolved administrations as well following Brexit. And then we have Stuart Wardlaw, who's a fellow partner of mine at Womble Bond Dickinson, and he leads our environmental practice, providing compliance advice, enforcement and transactional support to a broad range of industry and public sector, with a long-standing focus on the chemical and process industries. And hence, Stuart will be focusing in particular on how chemical regulation will be affected post-Brexit. And then last, but by no means least, we have Sarah Holmes, who is a legal director, also in our regulatory team. Sarah specialises in environmental law and in particular the interface between that and development consenting. She's a chartered waste manager and a member of the WBD Brexit group that evaluates and advises on significant implications for businesses that are leaving the EU, and also publishes information on our Brexit hub. So Sarah will round off our talks before our Q&A session, and she will focus in on the implications for waste management and its regulation. So without further ado, I would like to hand over to David for our first session. Thank you.
Thank you. The aim of the bill, which is to fill what some might regard as the void on Brexit of environmental law, given that something like 95% or thereabouts of our environmental law is EU derived, is to be filled by the Environment Bill. In its original form under the last administration, the proposals were very clearly set against the principle that we would seek to impose a new regime which was no less rigorous than the standards and the supervision found under EU law. And of course, that includes the overriding principles and duties in Article 192 of the TFEU. And you see in this statement by DEFRA last year that principle relating to mirroring the EU has been watered down slightly. And under the current proposals, it's simply these very fine principles to make sure that we leave the environment in a better state. And I'm just going to examine briefly, with regard to two main aspects of the regulatory provisions of the bill, whether or not we're on course to emulate the current regime, that is to say, the regime that's still in its transitional phase. Next slide, please, Josh. The timeline, you'll see, of course, that the Principles and Governance Bill, chapters 1 and 2 of the current bill, was first published in order to give rise to consultation in accordance with the obligations in the earlier version of the withdrawal agreement. That was published in 2018, before the 2019 general election, of course, and there was a detailed consultation and scrutiny by the draft environmental of the draft bill by the Environmental Audit Committee and by the Environment, Food, Rural Affairs Committee, and they both took evidence and both gave recommendations. There have been various papers setting out the government's proposals, the 25-year plan, about which others will speak, the consultation paper itself relating to the draft bill, and the government's response to the consultation representations and to the reports of the two committees. It's interesting to note that although there were some significant and important recommendations made, backed up by leading practitioners and academics in the field, many of the representations and the recommendations by the committees have not been followed by government, and they still remain important when you're considering the impact of the proposals. Next slide, please. The latest version of the bill, a version having been introduced just before the general election, was issued on the 30th of January, had its first reading then, and there's a useful compare version on the Parliament website, so you can see what additional provisions were added between the first version of the bill and post-election, the second version. The second reading took place at the end of February, and it was then committed to Public Bill Committee. There it stayed because as a result of lockdown, the proceedings have stalled, and although there was a statement since lockdown that they would resume on the 25th of June, i.e. tomorrow, yesterday there was a programme motion, and that has been kicked off further into the long grass, and you'll see there the current statement on the Parliament website is the committee is not due to report now until the end of September. There are various helpful or otherwise statements by government. You've got the explanatory notes to the bill, some of which is actually more helpful than the bill itself in terms of trying to understand what the government thinking is. You've also got policy statements, policy statement in terms of the general statement on the 30th of January that accompanied the first reading, and then a series of governance fact sheets, which are rather light on detail and explanation and very heavy on broad principles. There are, of course, many other consultation papers, not the least the consultation papers in 2018 and 19 on biodiversity net gain, which is a major issue under the bill, which I'm not going to touch on because that itself would take several hours of a webinar to go through. But it's interesting to note, for example, in that respect, the government's already given a commitment for a 2-year delay in implementation post-royal assent, which of course puts that even further into the future given the bill process delay. Next slide, please. The structure of the bill, everybody will be familiar with. Chapters 1 and 2 are the regulatory provisions, and chapter 3 contains modifications in Northern Ireland to the regulatory provisions, but then the substantive provisions on waste, air quality, water, biodiversity, and the like. And a lot of the detail, of course, is in the schedules. For example, Schedule 14 introduces the biodiversity net gain proposals, which bring about the introduction of a new Schedule 7A and some new provisions into the Town and Country Planning Act. Next slide, please. The objectives of the bill are set out in the explanatory memorandum. Don't need to quote it, obviously, but it's there for reference. It's to replace, as I said, the loss of EU environmental, or the governance gap, as it's called. And there are lots of fine statements about what's going to be done and what's going to be secured, particularly referring to the environmental principles, which is said work together to legally oblige policymakers to consider choosing policy options which cause the least environmental harm. It's interesting to note, though, that despite the fine words, the environmental principles are very limited in their application and in their scope, and they do not apply to all regulators. Next slide, please. The principle, as I mentioned under the earlier version of the withdrawal agreement, was of replicating at the very least the provisions under EU law, the principle of non-regression, as it was then called. And that was in the ill-fated Northern Ireland Protocol, which has now been significantly amended under the final version of the withdrawal agreement. So the 2018 consultation paper and the principles being discussed by the committees in relation to the draft bill, of course, should be read in the context that the commitment to non-regression underpinned the government stance then, which it no longer does. But there is still a commitment to a high level of environmental protection. Turning next 2 slides, please, Josh, to the environmental principles. They are listed, and they're the familiar ones from the TFEU. They're listed in the Act, but they're not further defined, and there's no definition either in the Act itself, nor simply by reference to EU law. And I've set them out for convenience. The embedding of the environmental protection in making policy, preventative action, the precautionary principle, next slide please, rectification of damage at source, and the polluter pays principle. And of course, we're all familiar with the important role those principles play, and they're embodied in the TFEU, of course, in the court's case law, and they run through the consideration by the European Court and action taken by the Commission. For example, the Wannsee case, which capitalised on the precautionary principle. Interestingly enough, the principles were described in the consultation paper in 2018, and their importance was emphasised. Next slide, please. But even then, paragraph 5 made it clear that this was going to be a matter for the government to set within its own policy framework and no further. The bill doesn't regulate the extent to which ministers can depart from the EU concepts, nor the reference points. And the reference to creating a new system tailored specifically to a UK context suggests that ministers reserve to themselves the power to take quite a different approach to how to apply and interpret those principles. And as I've indicated, the bill focuses on the issue of government policy and the making of a policy statement by government as to how it's to take forward environmental law and to apply it. And that is where the environmental principles come in. Next slide, please. As I've said, there are a number of fact sheets which are light on detail and heavy on general statements. You'll see the fine words that are used. But again, importantly, the environmental principles are not generally overriding or determinative. There is limited control by Parliament. There is the laying of the draft policy statement, which is meant to give effect to and interpret the environmental principles before Parliament. If a resolution is passed or a committee that considers it makes recommendations, then the final statement, taking those matters into account, must be laid before Parliament. But the control appears to be political. There's no requirement under the current provisions for an affirmative resolution, and it mirrors pretty closely in those processes the NPS process under the Section 9 of the Planning Act 2008. It's interesting to note, and I've highlighted the bits in red, that the policy statement explains how the principles should be interpreted and proportionately applied when making policy. So it's set at several stages removed from the actual actions of the regulators who have to apply the principles in everyday decision making. And the duty with regard to the environmental principles is only to have due regard, a phrase which causes most administrative lawyers to laugh hollowly. Next slide, please. Limited scope, no general duty, as in Article 191, only applies to the formulation of the policy statement, no general application to regulators, developers, operators, other parties, don't directly provide guidance that the courts can draw on for the interpretation of environmental law. Although through the prism of the Withdrawal Act, even as amended by the 2020 Act, there's still scope for the court to draw on European principles to similar effect. Of course, how the policy affects decision-making remains to be seen. And it's fair to say that the committees that scrutinise the original provisions, which are not that dissimilar from the current ones, was fairly critical about this distant role for the environmental principles, but their recommendations were not taken on board by government. Next slide, please. What this means, of course, is that government has a wide power to interpret and depart from those principles depending on how it determines to formulate its policy. And the due regard principle isn't much assisted by the explanatory notes, which simply say ministers of the Crown must have the correct level of regard. Well, I'm not sure anybody's going to be comforted by that, because as we all know, the ability of the willingness of the court to intervene to consider such matters is pretty limited. And the 14th report by the committees said it was too weak a duty and allows for aggression. Next slide, please. Ministers have a duty not to do anything or refrain from doing anything if doing or refraining from it would have no significant environmental benefit or would in any other way be disproportionate to the environmental benefit. So, in fact, even given the policy and the statement, ministers still have a very wide discretion as to how to act. And then you get some explanation in the notes rather than the act itself. Again, it's slightly worrying that both with the question of what the principles mean and how the duties to be applied, you have to look in the notes and you don't find any guidance in the act itself or in definitions that have been included. So on any view, there are several wide areas of judgment, and the extent to which the principles will underpin future environmental law is very much within a wide discretion given by ministers to themselves. Some of the amendments that have been tabled to date at Public Bill Committee, but of course they have yet to undergo scrutiny and report, suggest the removal of some of these Clause 18.2 matters such as proportionality, but of course the government seems unlikely to accept them because these were recommended to be removed in the first place by the original committees, and so even if the Public Bill Committee recommends their removal, it seems unlikely that they will change. And indeed, you'll see the government response. Next slide, please. On the 19th of December of 2018, in response to the initial consultation, and you'll see it simply dodges the issue, sidesteps is the polite word. The weak application of the principles makes a lot of fine statements about policy, but doesn't grapple with the lack of application of a general duty to regulators or decision makers. Turning then briefly to the Office for Environmental Protection, one of the key planks of the government regulatory procedure is to replace the scrutiny of the European Commission, next slide please, and the one after it, with the Office for Environmental Protection, because of course the Commission is the guardian of the EU treaties and of environmental law under the treaties, and it both monitors, scrutinises, investigates and takes infraction proceedings in the European Court if necessary. And there is some reflection of that role, both in the monitoring and scrutiny role and in the ability to take action in the provisions in the bill. However, although the principle of non-regression originally applied, one has to question, and many have questioned, whether this in fact achieves anything like equivalence with the role of the Commission. General proposals, you see there's been little change since the 2018 draft model. There have been some changes in terms of the review process and the role of the tribunal rather than the court, but judicial review is still retained. Lot of criticism, as I mentioned, in the reports by the two committees that scrutinised the draft bill, and the views of those commentators who gave evidence to the committees are publicly available and are worth reading. Next slide, please. As you'll see, the OEP is there to contribute to environmental protection, improvement of the environment, and it has scrutiny and advice functions and enforcement functions. It isn't, however, directly a regulator in the sense that the Environment Agency is. It doesn't oversee conduct by public authorities. Sorry, it oversees conduct by public authorities rather than directly regulating their decisions by being a decision maker. And that includes, but is not limited to, the Environment Agency itself. Next slide, please. As I've already mentioned, although the creation is to replace the oversight and enforcement role of the Commission, the OEP isn't going to be the Commission. It lacks its powers. And of course, its function is on domestic compliance by subnational bodies and does not consider compliance by the UK as a whole, whereas of course the Commission, and this is reflected in the way that infraction proceedings are brought before the European Court, it considers whether the UK as a member state has complied with European law, rather than pointing the finger and pursuing an individual regulator or decision maker. OEP isn't just looking at the broader question, it's focusing on the specific decision maker or regulator. And there you'll see some of the conclusions of the Environmental Audit Committee on this point. and it specifically laments the lack of collective accountability. Next slide, please. The scrutiny advice functions I've set out on this slide. Nothing surprising there, but it includes an advisory role if requested to by ministers to advise on changes to environmental law, but they don't have any freestanding duty to do so. Enforcement powers in relation to failures by public authorities to comply with environmental law. And you have a two-stage process, a little like the Commission. You have an investigation process with a decision issued, which is not binding, unlike the position in the EU. That can be followed by environmental review before the tribunal, or the Commission, the OEP itself can go directly for judicial review to the administrative court. Next slide, please. Failure to comply with environmental law is defined by clause 28. It is formulated as a type of Wednesbury test, whether the public authority has acted within its powers in a public law sense and not applying its own judgments to the facts. The government declined to take the power any further and said it wasn't necessary or appropriate. Now, the test that the Commission applies is manifest error of assessment, and some of the UK cases have said, well, that's broadly equivalent to judicial review and the public law scrutiny test. That is open to question, as indeed a number of commentators pointed out to the committees in 2018, including Professor Richard McCrory. If you look, for example, at the Commission and Poland case on habitats and wildlife, you will see a very high level of examination of the facts and a disagreement with the detailed assessments by the Polish authorities in relation to them. So it has to be questioned whether there is a direct equivalence between manifest error of assessment and the test proposed by the Act for the OEP to apply. But that said, the principle of non-regression is no longer being applied. Again, there's a public bill committee amendment which proposes that the tribunal should be able to review findings of fact and other matters, but that remains to be seen, and one expects the government to oppose it. Next slide, please. Public authorities essentially exclude a limited category of bodies, including the OEP itself. That would have been an interesting exercise, for the OEP to scrutinise itself, courts, houses of parliament, and the devolved legislatures. Anybody can complain to the OEP. Next slide, please. There's then an investigation, and there are duties to provide information and the like. The issue of fact-finding is open to doubt, as I've already mentioned, and the end of the investigation is a decision notice where the OEP is satisfied on balance of probabilities there's been a serious failure, not just any failure, to comply with environmental law. It must set out the failure that it's identified and the steps that should be taken to mitigate the failure or prevent recurrence. But that decision notice is not binding on the public authority, either as to breach or remedy, and the remedy can't include taking of steps, for example, if the local authority is functus officio. So if, for example, there was an environmental error in a habitats assessment which led to the grant of planning permission rather than refusal, it can't require the authority to review the planning permission. What it can do, next slide please, is in respect of a decision notice which it's dissatisfied with the response to, it can apply to the tribunal for an environmental review. The authority doesn't need to refuse, it can simply do nothing. That is a review of the alleged conduct described in the decision notice, and it's about the specifics of that defined review rather than the terms of the decision notice itself or the steps set out. And again, there's a proposed amendment which tries to tie environmental review more closely to the decision notice. And of course, in infraction proceedings, the infraction proceedings before the European Court are tied to the allegations which have been set out in the formal decision issued by the Commission recording the infraction, and the proceedings have to be defined by that. That's not the case here. And the upper tribunal is there to apply ordinary JR principles and grant ordinary JR remedies subject to matters such as hardship and prejudice to third parties. And that may not be difficult to show if, given the position under the review procedure, it's not subject to the general JR time limits. And of course, it is potentially the case that proceedings can be brought some time after the JR time limits have expired. Next slide, quickly. The OEP has itself power to seek JR, but that, of course, is limited in the way that JR is limited in terms of scrutiny of legal errors. The court can't refuse relief on the new statutory. It would be highly likely to have been the same decision. So if the OEP brings a JR, the court itself can't rule out a review on the basis that it doesn't think that the decision would have been different, although it doesn't necessarily refuse the exclude the discretion of the court at the end of the day. Again, there's no direct role for the review at the end of the judicial review. So what the authority does in response to the court's decision, or indeed the tribunal's decision, is not, like the Commission, itself subject to further proceedings. It may well be that the OEP could bring further proceedings under the investigatory powers and then leading to the decision notice procedure, but that would be a new set of proceedings rather than simply a tacked-on enforcement procedure, which the Commission has under EU infraction. So summarising the concerns, they're set out on the next page, and those are the matters I've already run over, and rather than taking up more time, they're there for reference. And you see that the overall conclusion is that both with respect to OEP and indeed earlier with regard to the principles, there are serious questions about the extent to which the new regulatory framework will provide the level of scrutiny and the power to intervene to secure compliance with internationally recognised principles of environmental law. Thank you very much.
Hello, everyone. I'm talking about environmental law divergence within the UK, rather than, as such, the divergence from the EU. And as you know, agriculture, fisheries, the environment, and some aspects of energy are devolved matters. So to some extent, the devolved administrations have been able to go their own way on such matters, even pre-Brexit. So two examples which I'm going to touch on are one, in relation to agricultural payments and the Horvath case, and the other is in relation to the structure and the scope of environmental regulatory agencies, which differs between the jurisdictions. The scope for divergence, though, of course, was extremely limited by EU membership, because EU law, the treaties, the regulations and directives applied to all parts of the UK. The EU general principles applied throughout the UK, and there was also the control exercised by regulatory institutions of the EU, such as the Commission, but also, of course, by judgments of the European Court. And the reality is that Brexit removes all such constraints and gives rise to an obviously far greater risk of divergence of laws within the UK. I want to start with Horvath, which is a case that takes us back over 10 years now. This was a reference from the High Court, which actually ended up on appeal as to whether there should be a reference. And the case arose because of what were referred to as the minimum requirements for good agricultural and environmental condition, the GAECs, which are referred to in Article 5 of and Annex 4 to a regulation which established the common rules for direct support schemes under the Common Agricultural Policy. And a breach of a GAC could effectively reduce or remove your entitlement as a farmer to cap support payments. Article 5 provides that member states shall define at national or regional level minimum requirements for good agricultural and environmental condition on the basis of the framework set up in Annex 4, taking into account the specific characteristics of the areas involved. The issue arose because in England, the GAEC standards included the protection of public rights of way. That was something you had to do to get your entitlement, but Wales, Scotland and Northern Ireland did not. And the question that was referred to the European Court was, where a member state's internal constitutional arrangements provide that different devolved administrations shall have legislative competence in relation to different constituent parts of that member state, can it give rise to impermissible discrimination for the constituent parts to have different standards of GAEC under the regulation? And the court answered quite simply, no. If you had a devolved administration that had legislative competence within your country, it was acceptable for you under the regulations to set different standards within your country to those that applied in other parts of the same member state. So there's always been areas where environmental law has been possible to diverge within the UK between the devolved administrations and England, and for that to be consistent with EU law. Horvath is an example. Another example is the implementation of directives, which of course also allow discretion to the member states about precisely how they do it, and therefore some divergence about how directives in fact operate. So, for example, in the Seaport case, there were very clear differences between the way Northern Ireland, Wales and England in particular had implemented the consultation requirements of the SEA directive, both in terms of who had to be consulted at the scoping stage and also the timing of various parts of consultation. And the European Court in Seaport didn't find that to be an issue at all. It wasn't the main issue anyway, but they didn't see it as being a problem that there were different rules throughout those jurisdictions. Moreover, of course, there's never been anything to stop the jurisdictions going further in protecting the environment outside of EU law. And I think a good example is the Environment Wales Act, setting out the principles of sustainable management of natural resources in Wales. One can see that as a particular Welsh environmental law, different to what one sees in the other jurisdictions, and perfectly consistent with European law to have that further level of protection. But in many areas of environmental law, the reality is that because of the dominance of EU law, as David said, something like 90–95% of our environmental law coming from Europe, it's often difficult, despite devolution having been around for so long, to discern a distinctly Scottish, Welsh or English, Northern Irish approach to these matters. What have been some of the advantages for England and for the devolved administrations of operating within a common legal EU framework for environmental law? Well, I think really several things. First of all, environmental issues do not respect borders. Obviously, there are further issues in relation to Northern Ireland and the Republic. So having this coherence allowed for a coherent and consistent approach to issues like habitat. So Natura 2000, for example, of course, which is a network of protected European habitat sites, goes right through the European Union. Moreover, of course, that is going to be replaced by the habitats regulations that come into force after the implementation period by what is now going to instead be called the National Site Network. But those kind of issues of environmental law do require cooperation, one might think, to work. Secondly, having the same environmental laws, or largely, has supported the UK's own internal market, so the same minimum standards apply across the various jurisdictions. And of course, also having the same rules from the EU across all supports compliance with international environmental obligations, which may well overlap with what EU law provides for. Now, all of these considerations remain relevant post-Brexit and support, surely, some kind of continued common set of environmental standards. But obviously the risks without EU membership are clear. Environmental law derived from the treaties, including the environmental principles that David's talked about, are no longer binding and applicable by EU law. So the overarching applicable principles may differ between the jurisdictions. The devolved administrations can legislate to depart from pre-exit EU environmental legislation. They're not required to transpose or adhere to post-exit amendments or new EU legislation. There's no role for the Commission, and there's no role for the European Court. And the result potentially could be less environmental protection, breakdown of the UK internal market, and there's been discussion already of things like, could there even be waste tourism between the different jurisdictions within the UK? But does it really work to have 5 environmental law systems in these islands? Well, does the Environment Bill provide the solution? Well, that's an easy one. The answer is no. And it doesn't take very long getting into that bill to see that why it doesn't provide the answer. So what is now clause 134, previously 130, and I think it may have been 127 before that, deals with the extent of the Act, so the territorial extent of the Act. And there is a 9-page annex to the explanatory notes, including a table that tries to take us through the extent and application of the bill, remembering that those two things are different. And this is just a small taster of how complex the situation is going to be. So, subject to a small number of exceptions, it tells us, the bill forms part of the law of England and Wales and applies to England. Around half of the bill's provisions extend and apply to Wales, with a significant number of provisions having Great Britain, the UK, or England, Wales, and Northern Ireland extend. Some of the clauses are Northern Ireland only, some apply to Wales only. Complex, yes. Providing unity, no. Take environmental principles, which David's talked about. The provisions for a policy statement by the Secretary of State on environmental principles and the provision for environmental improvement plans extends to England and Wales, but actually only applies in England. Part 2 of the bill does make provision for policy statements in Northern Ireland, but those are to be made by the Department, not the Secretary of State. Scotland is conducting its own consultation on having environmental principles and is expecting to have its own system for those. Wales, as I understand it, similarly expects to have its own bill in relation to those things. So the content of any policy statements on these environmental principles, and indeed the very statutory provisions on which they're based and their extent and their application, could all be different in the different jurisdictions. What about the OEP? Well, you might think that's going to provide some unity. The OEP is intended to be for the UK, but actually its role outside England is extremely limited, given that, as the explanatory notes explain, where a person is undertaking a devolved or parliamentary function, they will not fall within this definition. And this means that any public authorities implementing devolved functions under environmental law in Scotland, Wales, and Northern Ireland will not be covered by the remit of the OEP in respect of devolved matters. Bodies exercising functions would typically include Scottish Natural Heritage, Scottish Environment Protection Agency, Natural Resources Wales, and the Northern Ireland Environment Agency, unless and to the extent Northern Ireland has its own provisions that allows it to apply the OEP provisions to it. But there is effectively no control by the OEP outside of England in any meaningful sense from this bill. The government's provisions for Wales and Scotland are going to be the subject of separate devolved legislation. So those are some of the examples. Your main new overseeing authority could be different. It certainly has a different scope of application. The environmental principles could be entirely different. What about other examples? The environmental targets and monitoring provisions in the bill, England only. Waste and water resource efficiency, huge variation on the extent of application of those provisions. Some are UK-wide, some are only to some of the jurisdictions. The air quality provisions in the bill, mostly just England or England and Wales, some Northern Ireland only. Water, mostly England or England and Wales again, but note, I mean, this is the sort of classic environmental cross-border issue. There's specific provision in the bill on the cross-border management of the Solway-Tweed River Basin District, because that straddles Scotland and England. And as many of you will know, that is a classic interstate environmental case. It's about a river running between two different states. Nature and biodiversity and conservation covenants, those are England and Wales only, and then schedule amendments in relation to REACH. Well, overlapping jurisdictions on that, extremely complex set of provisions dealing with all of that. So divergence, where are we? Well, even looking at the bill alone, we're obviously looking at growing divergence. Different environmental principles, they may apply differently as well as to what their role actually is. Different environmental governance, different approaches to revising and amending pre-exit EU legislation, different approaches as to whether to follow and apply post-exit EU legislation, different higher or lower environmental standards between our UK jurisdictions, different technical standards and guidance, and of course different court decisions across these different jurisdictions. So what are the limits then to this risk of divergence? How might we avoid this? Well, it's clear on some issues there's going to have to be a coordinated approach. Waste and REACH, I think, are good examples. I mean, otherwise, the UK will cease to function as a single market. So how will you coordinate? One answer is through joint ministerial committee, and that's something discussed in a really interesting paper by the Institute for Government called Devolution After Brexit, Managing the Environment, Agriculture and Fisheries. And that talks about the need for four-nation agreements. For the UK, it says the UK and the devolved governments have agreed in principle to work together to develop common frameworks in some areas currently governed by EU and which are within the competence of the devolved administrations or legislature. So there's one level, there's ministerial level between the different jurisdictions, the potential for some cooperation, and indeed, frankly, a desperate need for it. There, of course, may well be continued cooperation between some of our other environmental bodies, the Environment Agency and its equivalent bodies in Wales and Scotland and Northern Ireland. They already produce and have produced in the past joint guidance, and they may, let's hope, continue to do so. You've also got things like the Joint Nature Conservation Committee, something that we already have in this country. Potentially, could it have a greater importance in bringing some unity? Two other things in terms of the limits to divergence. One is international conventions. Obviously, we're leaving the EU, but we're still going to be a party to a number of other environmental international conventions. Of course, first of all, the power to enter these international conventions lies only with the UK government. If they're unincorporated, they're not justiciable, at least in England, but they may have a more important role to play in terms of Scotland and in terms of Wales, because of the restrictions, for example, on the Scottish Executive in terms of taking actions that are incompatible with international obligations and similar provisions, not quite the same, that apply in Wales. So these international obligations could have an increased importance in environmental law generally, but also in providing some level of, some amount of unity within the UK jurisdictions. One thing I can't resist mentioning, people have talked for a while about international law potentially replacing EU law in terms of the background and the basis for our environmental law. And clearly, you know, the Court of Appeal's decision in the Plan B Heathrow litigation case would provide those who support that view with some support. The Court of Appeal effectively giving effect to an unincorporated convention in finding unlawfulness in the airport's national policy statement. That case is then going to the Supreme Court, not being taken there by the government, but going there because through Heathrow Airport Limited. The Supreme Court's granted permission. We'll have to see what happens on that. If you ask me to make a prediction, my prediction is the Supreme Court will overturn the Court of Appeal's decision in relation to that. And then thirdly, the UK Supreme Court, we've got the same judges who ultimately at the top level will be dealing with all of these laws. But unlike the European Court, they will not be able to provide the same unity because they will be applying different laws that are applicable throughout those different jurisdictions. And then looking at limits on divergence, there's one other potential limit on divergence, which may apply just to Northern Ireland. It may be that it applies more widely. It's important to consider the position of Northern Ireland and the Republic because of transboundary environmental issues. There are, of course, all kinds of international conventions about transboundary effects, ESPO, for example. There's also customary international law about the relationship between two countries in terms of environmental law. And obviously Northern Ireland is thus in a unique position in relation to the border and the need to more closely align to the EU. And there are already, and there have been in the past, difficult cross-border issues on environment in Ireland, for example, about the repatriation of waste. And what we know is, of course, from the protocol, the revised protocol and withdrawal agreement, the EU and the UK have committed to cooperate in relation to North-South matters, particularly on the environment, plus a number of other issues. Northern Ireland may well therefore inevitably be tied more closely to EU law as it stands today. And the question is, what will happen? Will it be that the Northern Ireland splits away from the rest of the UK in terms of its EU law, or will something different happen? And in relation to that, there is a question, I think, still about how closely Northern Ireland will be forced to tie its environmental laws to the EU. Some of those are provided for in annexes of the protocol. They will continue in Northern Ireland. But it's not just Northern Ireland, because the Scottish Government has on many occasions expressed its ambition to maintain close ties with the EU and to continue to keep pace with EU law after exit. And if Wales did that also, the division would clearly then be between England and all the other jurisdictions, with England moving further away from EU law and perhaps the other jurisdictions not. But how does that fit? How does that fit with the single market that we have had in the UK? So those are just some of the issues. There's a huge number of them, and they're all coming our way. I hope you found that useful. We're now, I think, going to have a 5-minute break.
Yes, thank you, James. So we'll just take a short comfort break, 5 minutes, and then start again with Stuart.
Welcome back, everybody. Good to speak with you all. And I thought it would be worth looking today at how Brexit is likely to play for the chemicals industry as one of those industries that is one of the largest net contributors to UK GDP, but also one that's particularly significantly affected by cross-boundary product flows in terms of the complexity of the supply chain between the UK and Europe. And therefore, not surprisingly, one of those industries that has been most vociferous in relation to what it sees as being an acceptable or most appropriate Brexit outcome once the referendum decision was taken. And it's also one of those industries that's most complex in terms of regulation and the breadth of regulation that applies to it, both specifically, but also more general regulation, which has significant consequence for the industry itself. So I've picked a few areas to cover off, and above and below the line, so to speak. The top three that I'm going to comment on are those that are very much chemicals specific. There are a whole load of others that we could think of there, like plant protection, regulation, but also below the line things like control of major accident hazards. But I think this is a sort of good representative sample to give you an example of what is emerging in terms of the regulatory landscape for chemicals. So we're going to touch on REACH, CLP, biocides, Industrial Emissions Directive, and that humdinger, the EU ETS. So if we could advance that slide, please. Thank you. And when you think about what is emerging in terms of the difference between if we have a deal or we don't have a deal, there's a bit of a common theme emerging, or certain common themes, but one in particular is that we establish a standalone chemicals regime, and to start with, on exit, the new regime is very much based on the existing one so that we have continuity and we're not throwing the baby out with the bathwater. But we make specific amendments to the legislation, such as enabling the Health and Safety Executive to take on the functions of the European Chemicals Agency, which is obviously a REACH-related issue. And then if we have a deal, and what's emerging is we're now ruling out inclusion in EU systems so that we avoid oversight by the European Court of Justice. It still looks as though we're going to establish a parallel regime. The difference between the two, and the devil is obviously in the detail, but the difference is that we may have some greater alignment with EU bodies, such as in the areas of data sharing and collaboration, but how far that goes is really the key question. I think we've touched on it earlier in both David and James's presentations, but there's still a significant lack of clarity around what this all means in terms of detail, and some of the guidance that's been out there has now been withdrawn or is no longer accessible. Next slide, please. So just looking at REACH, which I think is almost the kind of litmus test, really, given its importance and foundational importance nowadays to the industry. There's been a very long-standing industry preference, and they continue to express that, that we should stay in REACH and continue to be involved in the European Chemicals Agency, directly involved in that. And as recently as February, the CIA and the European Chemical Industry Association and the European trade body CEFIC were making it very clear in a joint paper that in the event of no deal and adopting a separate UK REACH-like regime, we risked triggering substantial disruption costs, complexity and burden for businesses in both the UK and the rest of Europe. And they've put that cost at over £1 billion with no real environmental benefit and potentially forcing duplicate acting, including going against the important principle of last resort of animal testing studies. So really not benefiting industry whatsoever. However, we're now starting to get some clarity 4 years on from a recent correspondence communication from the government. And if you could advance the slide, please, Josh. The Environment Minister, Rebecca Powell, wrote to the Environmental Audit Committee on the 22nd of May in relation to REACH, setting out that the UK will retain the fundamental approach of the EU's REACH system and create a UK REACH system. We will, and this is of great concern to industry, not seek membership of the EU system so as to avoid ECJ oversight. However, in terms of more promising, and this is the area I think industry is wanting the government to work on, an annex to the proposed trade agreement states both sides should agree to develop a memorandum of understanding between the HSE and ECHA. Again, the devil is in the detail there. How far that goes and what level of collaboration that gives rise to is really uncertain as yet. So from the industry's perspective, there's all to play for. The letter also notes the fact that the chemicals strategy that's being developed has been paused due to the pandemic. Next slide, please. And really, in terms of that area for collaboration with the EU and ECHA, it's really about access to the database of chemical information that is so well developed as a consequence of REACH in its various iterations. And the CIA have been focusing on Article 120 of REACH, which allows ECHA to share information with a third country government or national authority to cooperate on chemicals management. And this is being seen as very much an opportunity to form the basis of an agreement as we move through the trade talks. The CIA themselves are currently focusing on developing ideas on how a data sharing mechanism could work to inform those negotiations. And they wrote to DEFRA again earlier the outset of this month, again still expressing the view that we'd be significantly better off within REACH and ECHA, but in the absence of that, the fundamental need to be part of database access so that we're not having to duplicate expensive investigative studies, including animal testing. Next slide, please. And similarly, and again, you'll see this theme emerging right across the piece. CLP, the Classification, Labelling and Packaging Regulation, which has also become very key to chemical manufacturing and distribution in Europe, will have an independent regime, we're told, based on European CLP, again with the HSE performing European Chemical Agency's functions. So that's going to replicate, once again, pretty much everything for the time being that passes in European CLP, so that manufacturers, importers and downstream users have to classify, label and package substances and mixtures that they place on the market. Suppliers will have to identify, examine and evaluate scientific information on substances and mixtures to ensure all the requirements of classification are fulfilled. Testing arrangements the testing requirements and restrictions will continue, and manufacturers and importers will have to notify details of self-classifications for substances they place on the market, but now that'll be to the Health and Safety Executive. Next slide, please. And again, similarly on biocidal products, on no deal, we're going to establish a biocidal products regulation-like framework, but equally, if we have a deal, that there will be some form of that, but equally closer cooperation. To what extent remains unknown. So again, the HSE will be still the competent authority for the UK, but will take on the Chemical Agency's role for active substances approvals and product authorisations. For continuity, current approvals and authorisations will remain valid in the UK until their normal expiry, and authorisation holders would need to be established in the UK with a phase-in period to give businesses time to make arrangements. One thing that's not clear, however, is what will happen to biocidal product applications which are still being processed by the HSE or other European competent authorities after the transition. Next slide, please. And then of much wider application, but obviously of critical importance to the chemical industry, given the processes it operates. In terms of industrial emissions, where we will continue with the long developed and established integrated pollution control system for industrial emissions across the various sectors impacted by them, in particular the IPPC type controls. And we, for now, the way that's going to work is existing EU law will continue to have effect, including the directive and the BAT conclusion implementing decision. What is very significantly different, however, is that the UK will no longer be part of the Seville process for establishing best available techniques for different industrial processes via the BREF notes from the 1st of January. Next slide, please. So we have secondary legislation will implement the Industrial Emissions Directive and make the necessary changes to give effect to European law for the time being, ensuring that the existing standards, the best available technique conclusions, have effect in UK law. And then going forward, provide powers to adopt BAT conclusions separately in the UK and empower the devolved administrations to determine best available techniques. And that's an interesting area for, rather like what James was saying about divergence, there's the potential for divergence on divergence, which could get complicated, and one would hope that there's a degree of conformity within the UK to avoid the sort of disruption of the UK's internal market. I read somewhere that the Clean Air Strategy for England sets out the sort of actions that are going to be taken for determining future UK BAT for industrial emissions. Well, having read them, I can't see that they do. They give, rather like David was saying earlier, that they're long on principle and short on detail. I think the however, and what the principle in particular sort of boils down to is that there is an aim to ensure that future UK BAT regime takes a collaborative approach between government, regulatory authorities and industry, as currently happens within the European Union, but how we will generate UK specific standards and how they will consider the extent to which they'll consider the EU's position, which is obviously well developed through the collaboration between all member states through the Seville process, is yet to be decided and understood. Next slide, please. Again, EU ETS starting to sound familiar in that we're going to put a Union Jack on the EU ETS and create our own system, which, like the established ETS, will apply to energy-intensive industries, power generators, and aviation, and involves combustion, where you have a total rated thermal input of 20 megawatts plus. One difference will be that as against the anticipated, you'll know that this is a cap and trade system, and as against the anticipated allocation for the UK, if we'd been going into phase 4 of the EU ETS, the UK government has decided we'll set the overall cap at 5% below the notional share we would have received going into phase 4. So there's a statement of intent there in terms of achieving improved carbon reduction. And then on top of that, the government is saying it intends to go further in line with seeking to achieve net zero. Next slide, please. And again, this will all be familiar to people who get involved in advising on and being subject to EU ETS, but participants will have to surrender enough allowances per tonne of carbon emitted to cover all emissions, with penalties up to £100 per allowance. It's currently €100 in Europe. Again, there'll be a proportion of allowances allocated for free as per EU ETS, and free allowances will be made available for new entrants as well as existing operators, as with EU ETS. And again, sort of tantalizing us with collaboration and conformity and alignment. We're told that the UK is open to considering a link between the two systems, so potentially, excuse me, potentially trading across jurisdictions if it suits both sides' interests. So it'll be important to see where that goes, and no doubt industry will be lobbying very hard to create that alignment. Next slide, please. So just to wrap up, really, where are we going with chemicals post-Brexit? Just last week, before Parliament, the Environment Amendment Regulations 2020 were laid, and this has implemented as UK law another 32 directives, EU directives, adding to those adopted in last year's amendment regulations. And this now includes industrial emissions, energy efficiency, and other particular areas relevant to the chemical industry, such as landfill and waste and water framework directives. So you know, very much taking that sort of macro approach of applying EU law across the board in the UK with specific variations. I think the EU are somewhat frustrated. Perhaps they would say that, wouldn't they? But certainly the recent report from the EU on the status of talks, and very much endorsed by the overwhelming majority of EU parliamentarians, calls for the UK to remain dynamically aligned to European chemical safety legislation, and particularly REACH. And I think that dynamic alignment point is something that is very much at the heart of the concerns of UK industry, and in particular the chemical industry. And as I've mentioned, whether we get a deal or don't, we are largely adopting EU standards by mirror systems, which, personal view, but they are likely to be at best a significant administrative burden having these duplicate systems. I think the saving grace and the hope in terms of widening the potential for dynamic alignment is that by adopting mirror systems in this way, we have the potential to avoid excessive divergence, at least for now, and clearly the rest is for the future and all to play for in terms of how divergence goes. And it'll be fascinating to see how pragmatic our government and the EU prove to be in terms of achieving any form of positive alignment. So I'll leave you with those thoughts and hand over to Sarah, if I may.
Thank you very much, Stuart. We originally planned this seminar, rather than a webinar, to take place in our Plymouth office the night before the start of the annual conference of the UK Environmental Law Association. So to keep the spirit of that, I have a backdrop of the view from my office before COVID-19 relocations, and there's a picture of a nasturtium on my shelf which came from Landmark Chambers at a previous UKLA conference gift. I am going to touch this evening on waste management in the UK after the 31st of December 2020. As Winston Churchill wrote, united wishes and goodwill cannot overcome brute facts, and there are some particular concerns in the waste industry regarding what will happen after the 31st of December. So I'm going to quickly look at where we were as our baseline, look at where we know we will be on the 1st of January 2021, look at where we could go after that date, how we could get there, and just provide some comments on how businesses can prepare for the changes ahead. So where were we? We've heard from David, particularly about the background to UK environmental law very much being based on European law. And my own career started in 1989 with the passage of the Environmental Protection Bill through Parliament, and I have been working on waste-related law ever since that time. So very familiar with the emergence of the 4 principles that we've spoken about in 1999. And in terms of the prospect of Brexit and the impact on the waste sector, I think one very good source to go to is the review of the balance of competencies, which was undertaken between 2012 and 2014, described by the then coalition government as the most extensive evaluation ever undertaken by any member state of what it meant to be a member of the European Union. And in respect of waste, the sector was involved in the report on environment and climate change. And I have just put on the PowerPoint slide there 2 extracts from the report, observing that it was considered by a large number of organisations to be in the UK's national interest for the EU to have a degree of competence in the broad areas of environment and climate change, and particularly because of the single market and environmental protection. And the waste sector was one of those where the regulatory framework was generally welcomed. I've put on this slide the summary of some of the pros and cons of shared EU competence in waste management, taken again from the balance of competencies review. On the pros side, the minimum standards are considered to have produced environmental benefit within the UK, with the targets and the obligation on the government to move, successive governments to move towards those. Also, cannot understate the importance of the level playing field in enabling the UK to participate in the single market, and the degree of stability that provided for the investments in the waste infrastructure that we now have, moving away over the last 30 years from landfill to other sources of waste recovery and disposal. On the con side, the challenges largely related to small and medium-sized enterprises finding it difficult to keep up with the pace of change. Again, regulatory burdens for SMEs, some concern that EU law could impact competitiveness and cause carbon and waste leakage. And of course, we have the China example for plastic waste and recycled waste, and that some actions were considered to go beyond those needed under subsidiarity and proportionality principles. But to be fair, my personal view is that most of those issues are those that will arise in any case for SMEs and not specific just to EU sources of law. So where will we be on the 1st of January 2021? Well, we know that in England, Wales and Scotland, in terms of domestic waste management practices, business should very much continue as usual. The legislation has been laid before Parliament to make the appropriate changes to the legislative framework in order to substitute references to European institutions and to remove obligations for the UK to report to the European Commission, for example. We don't yet know whether we will have an Environment Bill or an Environment Act, because as David has already explained, the Environment Bill will not now return to Parliament for consideration until the autumn. And in terms of the movement of waste between Great Britain and the European Union, we will no longer be moving waste under the EU regulation on shipments of waste. We will instead undertake movements on the basis of the Basel Convention primarily, and I will cover that a little later on in this presentation. As far as Northern Ireland is concerned, things will be different, and yet for internal markets they're the same, because under the protocol on Ireland and Northern Ireland there is a commitment to maintaining the necessary conditions for continued North-South cooperation, and the environment is one of those areas in which cooperation is to continue. Of course, the changes made to the withdrawal agreement by the Johnson government just before Christmas last year mean that the Irish Sea now becomes the de facto border between the European Union and Great Britain. And it is exceedingly difficult to see how that will not be anything other than a pretty substantial customs and regulatory border, which will of course impact on the movement of waste from Northern Ireland to Great Britain, but not between Northern Ireland and Ireland. I've listed on this slide the EU law that will continue to apply in Northern Ireland. You'll see that includes shipments of waste, packaging and packaging waste, so the targets there will still continue to apply, similarly with batteries and accumulators. There are some notable omissions from there. The Waste Framework Directive is not one of those directives listed, and I will look a little later on in this presentation at the extent to which the countries within Great Britain will be able to move materially from that without impacting adversely on the waste industry. So turning to look at shipments of waste between the UK and the European Union from the 31st of December, as I've said already, shipments of waste from the UK to the European Union will move to be controlled under the Basel Convention and the OECD in terms of recovery of waste. So required declarations, notification documents, movement documents, contract provisions, which we're very familiar with because the EU waste shipments regulation incorporates those provisions. The one big area of change is in terms of the new customs border, which is going to be very different for some businesses who are not familiar with export declarations and rules of origin and necessary certificates of conformity where those are relevant. Nor do most of the businesses that I know that move waste from the UK to the EU 27 currently deal with customs declarations themselves, and therefore they're likely to find themselves involved in looking at whether their carriers are able to provide the customs expertise, or whether they will need to contract with some of the agencies that can provide those services in order to reduce the delays at the border. There are obviously other indirect economic factors arising out of the change in the UK status from the 31st of December that will impact on the commerciality of waste movements. Those include obviously exchange rates, the rate of sterling particularly, what happens with landfill tax, whether tariffs are applicable or not. DEFRA says no, particularly for RDF, and the cost of conformity assessments if required. Moving on to shipments of waste from the European Union to the UK, there will be a change because the European regulation prohibits the export of waste for disposal and also prohibits the export of mixed municipal waste for recovery operations. And the UK has facilities that accept both categories of waste. And the issue of the export of waste from Ireland into the UK is one where we do not yet know what will happen in the event of no deal, an area where some arrangements are hoped to be in place to enable that waste activity to continue. In terms of EU waste coming to the UK for recovery, then in terms of the targets for WEEE, batteries, packaging, end-of-life vehicles, and so on, those can count towards EU waste targets for the exporters if the UK treatment remains equivalent to directive requirements. If there is divergence there, then obviously those waste shipments would not be permitted. And in terms of the waste streams, I've just picked two that I know a little bit about, where we send waste from the UK into the European Union as now as refuse-derived fuel, a relatively new market since 2010, but plays a significant part in the UK's waste management framework. And there are concerns there, hopefully not so much about tariffs, where it's hoped that it will be seen as a service rather than a good and not subject to tariffs if we don't get a zero tariff agreement. But in terms of practicalities over the customs process and the border clearances, where there are undoubtedly new barriers and practical issues that aren't really yet factored into a lot of the decision making. Secondly, air pollution control residue, which is a hazardous waste. We're dealing with quite a number of APCR instructions looking at alternative uses in the United Kingdom and whether we can retain more of that in the United Kingdom. But if there is a divergent, if there is a move away from exporting those wastes into the European Union, then they will consume landfill and other capacity within the UK that is not Great Britain. That is going to put a significant strain on waste disposal options for other parties across the sector. So, looking ahead at what is the plan? The ambitious 25-year plan to improve the environment does include focus on waste minimisation, reuse of materials and minimising impact. And I've put up on the slide the various targets that are being sought to be achieved. And we had last year the publication of Our Waste, Our Resources, the strategy for England in terms of our waste management going forward. And there is an emphasis there on the promotion of the circular economy, which the UK has been certainly very involved with, in my experience, in working with businesses on the continent, particularly businesses which have operations in both the UK and continental Europe in terms of the movement of products, byproducts, and keeping their systems as efficient as they possibly can be in order to promote the move towards a circular economy. How that goes forward will very much depend on the commerciality of sending waste into other countries for treatment. And if we do not have sufficient investment in the Great Britain for handling the types of waste that will be generated, and in the treatment processes in particular, then it's unlikely that many of the objectives will be achieved. So looking at demand for waste management in the UK/GB, because the Northern Ireland Protocol obviously envisages a review after 4 years by the Assembly of Northern Ireland. The short-term businesses that are exporting into the European Union may well find that their goods will be rejected at the pre-GB departure points. For those ports in the UK that do not have sufficient capacity within their own estates in order to process customs checks before the vehicles drive onto the ferries, arrangements are being made for off-site facilities. And for example, in Plymouth, there were 2 areas identified out of the city where all lorries heading to the port would be directed so that the paperwork could be checked, because vehicles are not permitted or will not be permitted to board ferries unless the paperwork is in order, because if the lorries get to the other side and don't satisfy the requirements at border inspection posts and customs posts in the European Union, then they will be rejected and need to be, they will be turned away, and ferry companies do not wish to have responsibility for repatriating them. So it is quite possible that goods will be rejected at pre-GB departure points. For goods that are subject to sensitivities over timing, for example, fishery produce, which is highly sensitive, delays of any particular length of time may be devastating to the quality of the consignment, leading to it to be returned, and waste provision need to be made. As I've said already, if we aren't able to maintain our existing flows of waste into the European Union, particularly for the refuse-derived fuel market, then there will be pressure put on existing UK waste infrastructure. Likely that we will see some loss of waste imports for treatment in UK facilities as a result of the prohibitions placed on EU countries for sending waste to non-EU countries. One of the issues which is affecting all sectors is predicted capacity constraints in the haulage sectors, because lorries will take a lot longer to make trips into continental Europe owing to the border controls, and that is even in ports such as Rotterdam, which have invested very heavily in preparing for Brexit and have a lot of IT available to reduce the times available. Interestingly, Rotterdam Port, an excellent website if you want to find out more about trading and Brexit in the future, predicts that on the Dutch side alone, 400 vehicles a day are likely to turn up with incomplete or incorrect paperwork that will be not be permitted to board the ferries until it's resolved. And obviously, every time we have constraints on our waste management capacity, it leads to an increase in fly tipping and illegal waste disposal. So those are some of the issues. Because we have no new model to move into, we don't yet have any gains effectively to identify at this time. In the short to long term, in terms of waste generation, there's obviously a contraction in the economy predicted, especially from the reduction of economic activity in sectors which have been very much based in the single market. Quite a lot of those businesses affected have made arrangements to mitigate impacts, either by establishing transition hubs in Rotterdam or setting up facilities in the European Union to remain, to retain their access as members of the European Union. But not everybody has been able to mitigate effects, and we know that the car sector is particularly vulnerable, and construction activity likely to follow, and the food sector is also particularly vulnerable to a no-deal Brexit and will face considerable new bureaucracy in any event under the government's preferred form of Brexit. But looking into the middle and, long term, there is potential for greater development of the circular economy, for the government to promote innovation and investment, but it will, I think, depend very much on the direction of government policy, the ability of the regulatory regimes, not only in terms of what the laws say, but the ability of the regulators to effectively regulate, which means that they need to be adequately resourced. There are multiple other factors that will be relevant in the extent to which the UK, Great Britain, is able to develop a circular economy. And I've listed those obvious ones: the product standards, energy and efficiency, the extent to which we're able to develop green infrastructure, some quite exciting work there on biodiversity net gain. And the relationship between import standards and domestic standards, which will obviously have an impact not only on the ability of UK entities that generate waste to retain or to remain in business. Maybe they'll innovate as part of those commercial pressures if the standards do diverge. But with import standards, if those are lower than our regulatory standards domestically, it will have a potential impact on the waste stream because of new substances, potentially toxic substances, chemicals, pesticides and so on, entering our waste stream, which we do not currently have here. And that could obviously have a knock-on effect in terms of exports of waste if those do continue to go to the European Union. Many other factors, role of foreign direct investment in the UK, much of which is obviously here to be in the single market and have access to the EU trade arrangements. And crucially, which I think is not always understood, is how important the values that are modelled by leaders are in affecting and influencing the behaviour of everybody else. So where could we go, or where can we go? One of the complaints, as I noted at the start, about waste is that it is pretty bureaucratic. In terms of opportunities to change the definition of waste, either across Great Britain or individually, if there is divergence within the Scotland, Wales and England, there is a potential, because we won't be subject to the EU Waste Framework Directive. Problem with diverging from or changing the definition of waste is that it then impacts on our ability to move waste into the European Union for treatment. In terms of the duty of care for waste, there is again the opportunity to simplify that, particularly for perhaps small and medium-sized enterprises. But the problem again arises in terms particularly of waste exports in exporters not then being able to be accurate in terms of the waste that they are seeking to export. And in hazardous waste classification, which has become tortuous since the REACH classification was moved into the definition of hazardous waste, and WM3, which is challenging for many businesses to navigate, and does lead to some instances where it doesn't seem to be environmentally sensible. And I've given the example there of utility waste, where roads are dug up, the waste is by the side of the road, the operator rings up the carrier, asks them to come and collect it, it gets taken to landfill site, and the question then is whether the carrier has the documentation to prove that it is not hazardous waste before the landfill operator will take it. So maybe some movement there, but again, it's challenging because of its alignment with chemicals classification, and I can't help but feel that there must be easier ways of changing our domestic arrangements in order to make it easier for businesses to navigate. Another area where there could be divergence is in terms of targets. Do we have them or do we not? Certainly the environment plan won't work if we don't have some form of targets, but there could be a shift from weight-based targets from recycling, for example, in order to promote other sources of, to shift the focus away from paper and into some of the other lighter materials for recovery. Waste minimisation, we do need a more effective waste hierarchy, but I think that is more a question of enforcement and application than anything that the UK could do differently. And in terms of end of waste and the chain of utility, the UK has a history of intervening in ECJ cases in favour of arguing for the chain of utility, where materials should not be regarded as waste whilst they still had some use, and that obviously did not survive various ECJ decisions. So maybe the UK can have a look at, GB have a look at definition of byproducts and see what we can do to keep more goods out of the waste regulatory regime. Waste Protocols Project is a way of reducing bureaucracy by enabling businesses to confirm that they're able to comply with the criteria set out in those, so hopefully those will be retained. And one of the things that has come up previously is the angst at the scale of resources that we send out of our country for exporting for waste treatment rather than retaining it here, where if we were able to have investments in sufficient capacity for waste treatment, we could be far more efficient in the use of resources and keep costs down. So how do we get there? Well, delivery of greater self-sufficiency in waste management needs a simultaneous focus on waste supply, driving down waste generation, and an increase in the capacity for waste treatment. Crucially, and this is very clear from my 30 years in the sector, it requires stable, coherent, evidenced policy and regulatory framework with a well-resourced regulator in order to deliver. And as Claire said at the start, I do a lot of work in the interface between the environmental world and development consent. And in terms of the planning system, its failure to deliver consistently is in no small part due to the fact that it changes virtually every time we change the Secretary of State, let alone a legal framework. So I do hope that the environment will not go in that direction. Anyway, to conclude, as Margaret Thatcher said in 1992, 5 years isn't long. Indeed, it barely takes you into the next Conservative government. It means that business needs to prepare itself quickly, starting right now. That was obviously exhorting businesses to prepare for the advantages of the single market and the reduction in barriers to trade with the European Union. We are now 6 months away from leaving that single market, and it is an inevitable and unavoidable consequence of that significant new barriers to trade will be erected. There will also be opportunities, and as Margaret Thatcher also said, awareness is the start of the battle. So in terms of businesses preparing for 31st of December, can I stress the importance of good housekeeping? If you can tidy premises to get all unnecessary waste off the premises, or processes completed to get waste generated and then off the premises, then that would be useful for you and avoid some of the issues that have arisen during the COVID-19 lockdown with the regulators in the devolved administrations and the Environment Agency issuing regulatory position statements to permit storage of waste at premises for longer than necessary, pending the resumption of waste business as usual, but it will not be waste business as usual necessarily after the 31st of December. So that needs to be taken into account. Good housekeeping, always a good thing to do. If you are a producer of waste that is exported to the European Union now, then it is important to understand the chain through which your waste will go, contact the carrier, understand the new costs and new bureaucracy. Please check your contracts and understand what Incoterms provide, because many contracts have Incoterms references that have never been used because there's been no need whilst we've been members of the European Union. Those will now apply, and if you haven't read them, you may otherwise find that you are responsible for some of the customs processing that takes place on the EU side of the border, which is where the tariffs are paid and where the inspections and so on are undertaken, and will be the responsibility of the importers going forward. For those with cash to spend, there will be businesses who are distressed, and there will be opportunities there. In the longer term, challenge to government is to provide the robust and coherent legal frameworks and economic conditions that are essential to deliver the circular economy and the innovation infrastructure that we need. The challenge for the government is that it has committed the UK to legal instruments and policies, the consequences of which will be to deliver smaller domestic markets, high new trade barriers and bureaucracy, especially for UK located entities, a disruption of supply chains, not only between the UK and the European Union, but UK and the rest of the world, less food and energy security, and instabilities and fractures in the UK/GB internal market, as James has said. So strong leadership, strong and effective leadership is needed. And for businesses, awareness, do your SWOT analyses, understand the risks and the opportunities, have a plan, get involved with your trade and business organisations so your voice is heard. Make sure you've got the right people on your team, creative minds, and committed and wide engagement. And the law is all about relationships. It defines all formal relationships. Make sure you understand the laws that apply to your businesses, and read the small print in your contracts. Thank you.
Thank you very much, Sarah. Thank you, everyone. We have a little time and we do have some questions. I don't think we will get cut off at precisely 7 o'clock. So if you are able to stay, we'll try and answer some of the questions that have been raised. David, if I can start with you, we've had a question specifically in relation to neighbourhood plans and the requirement that currently exists that they have to be assessed against the relevant European obligations, and what is likely to happen in that respect.
I was just going to say the answer is very straightforward, but it's anything but, because it requires you to look at a number of things. What we've got is a set of EU exit regs that are applicable to planning and miscellaneous environmental matters such as permitting and environmental assessment. The environmental assessment and miscellaneous planning amendment EU exit regs 2018 number 1232. I mean, it really rolls off the tongue. And you'll find that regulation 2.4 of those regs amends the reference in paragraph 8.2f of Schedule 4B to the 1990 Act to substitute EU retained law for EU obligations. And EU retained law is defined in a labyrinthine way by the EU Withdrawal Act 2018 as amended by the Withdrawal Agreement Act 2020. There are a whole load of EU exit regulations, and they all are said to come into force on the exit day, but as James tracked down when he and I were discussing this, it took forever to find it. Schedule 5, paragraph 1 of the Withdrawal Agreement Act 2020 says that all regulations that are said to come into force on exit day, in fact, come into force on IP completion day, which is the end of the transition period in December. So EU retained law substitutes for EU obligations.
Thank you, David. So yeah, not a straightforward answer. And actually on the back of that, we've had I guess to some extent, a linked question. Please, can you give your view on why net biodiversity gain does not apply to NSIPs in the Environment Bill? Again, that might be a broader question, not just for you, David.
Yes, well, the mechanism they've chosen is paragraph 13 of the new draft Schedule 7A for the Town and Country Planning Act. And biodiversity net gain is imposed by the deeming of a condition on all permissions to provide a biodiversity plan. And that doesn't appear to apply to the 2008 Act. I don't know whether that's an oversight or not, or whether it's intended to amend in due course the 2008 Act to bring it into line by requiring any consent granted under the 2008 Act to achieve something similar.
Okay, thank you, David. And given the response to the first question, obviously you have attempted to familiarise yourself with the detail of where some of these amendments are hidden. Are we expecting a consolidated amended set of regulations to be issued before implementation?
No. There are. I did.
Sorry, so the person who answered that question, asked that question.
I gave a paper. I think it was at the Oxford Planning Conference last September, and I think by that stage I counted there was something upwards of 600 EU exit regulations. So I think they're just doing it all in that way, and which is why finding the obscure provision in Schedule 5.1 of the Withdrawal Agreements Act about the substitution of exit there. James definitely got the gold star for that one, because we'd been talking about it and I was scratching my head trying to work out what happened. But it's just going to be left as it is, and the regs will all be amended in accordance with the exit regs in due course. For example, the conservation of habitats, the EU, the environmental permitting regs, the environmental assessment regs, the relevant bits of the Town and Country Planning Act, and they'll all be changed to make them workable in a non-EU environment.
So I think in a nutshell, it's going to be incredibly complex and not as straightforward. It already is, yes. Plenty of challenges.
I'm discerning some disappointment from the questioner there.
Yeah. I think that's how I interpret that as well. So just one last question for you, David, and that was just to comment on this new environmental remedy for the OEP, and how effective do you think that will be?
Well, the problem is you've got a division into two. You've got environmental review, which is on effectively JR grounds, and you've got JR by the OEP. The environmental review can only be brought if it's a serious breach. And you've got to ask the question, well, if there was a serious breach anyway, isn't someone going to JR it? And what does it add? The answer is, what it adds is the ability of the OEP to do an ex post facto analysis or archaeological trawl through the decision making. But it does bring up the context of challenging a decision a long time after it was made, because one of the prerequisites to being able to bring an environmental review in the upper tribunal is that the JR period must have expired. So it can only be brought after the JR period's gone, hence the prejudice element. So if you've got environmental permits or planning permissions or any other form of consent being challenged, it's going to be outside the normal statutory challenge period or the JR period, and that seems to be its biggest contribution. I mean, it's made all the more nonsensical if you look at the Northern Ireland provisions in Schedule 3, I think it is, of the bill, where there isn't an environmental review as such to the tribunal, because it's simply another JR to the High Court. So you've got two forms of JR to the High Court, which are created. The provisions are broadly parallel in Northern Ireland, but environmental review is specifically stated to be a form of JR. So you've got the JR on the environmental review, which arises out of the decision notice, but you've got an ordinary JR that the OEP can bring anyway without waiting. So it's creating a lot more complication without the teeth that the Commission has at the moment.
Yeah, I think that's the key thing, isn't it? James, if I may come to you, there's a question here in relation to the approach for Northern Ireland and whether or not they're likely to remain more closely aligned with EU environmental law. So, thoughts on that and whether or not, there could be some parallel systems there.
Well, I think inevitably, because of the protocol to the withdrawal agreement as amended, Northern Ireland is going to be more closely tied to EU law on the environment. And I mean, Sarah touched in her talk on some of the waste-related legislation that will still apply, but there's quite a lot of legislation that is indicated in the schedule will continue to apply. So I mean, inevitably, Northern Ireland is going to be more closely linked to EU environmental law. I guess the question is whether it will, in that way, diverge from the rest of the UK, or whether, because Northern Ireland has been pulled more closely to the EU by what's been agreed, the rest of the UK will go with Northern Ireland and stay close to the EU. Unfortunately, I don't think that's what's going to happen. I think there will be this divergence between Northern Ireland and certainly England, but perhaps also the other jurisdictions.
Thank you, James. And then just on the back of that point, you talked about the lack of unity, clearly, and with the risk of the divergence by the devolved administrations. Again, just keen to sort of get your view there on actually, the potential there for that to have an adverse effect on the environment, and for us to spend more time in disputes with each other rather than ensuring the protection of the environment.
Yeah, I mean, I think that's possible. I mean, I think this idea of four-nation agreements on environmental law matters seems something that's absolutely necessary, and that's very much the view of the Institute of Government in their paper. And there seems to be recognition from everybody that you are going to need to have some kind of four-nation agreements on environmental matters, probably not principally because of environmental protection, I say principally because of internal market, but also for environmental protection. The problem is that there are so many challenges. I mean, one of the things the Institute paper does is list in some detail what the challenges are to getting those agreements in place. I mean, the first one is agreement being reached, which is itself a bit of a nightmare one, and then they've got 6 more to boot, which aren't any, actually, when you look at them, aren't much easier than that one. And of course, we've got plenty of time, haven't we, to sort this out, because it's what, 6 months away.
Loads of time.
Loads of time, and I'm sure there's nothing else going on, so it should be fine.
Absolutely. Thank you, James. Stuart, if I may turn to you, we've had a question in relation to the implications for BAT decisions that are still to be determined. And how those will be implemented now that we don't have to adhere to the Seville process anymore.
Well, in a way, I think my answer might be similar to James's last one, which is we've got loads of time to develop our own BAT conclusions between now and the 1st of January 2021. What's the problem? But we're not going to have, we're not going to have the Seville process available to us after that date. So BAT conclusions that are established will be carried forward for the time being, but we still have to get that in place. It'll be interesting to see how that's developed, and particularly given the choreography that needs to take, well, hopefully will take the devolved administrations with the UK government. So that is very much a live issue, and one we can't give a definitive answer to for the time being, but clearly we need answers to, and industry needs answers to.
Sarah, I think you said you could add a point on the biodiversity net gain point that was raised earlier as well.
Yes, the UK Environmental Law Association Nature Conservation Working Group had an excellent presentation on biodiversity net gain in May, and we understand that the reason it's not explicitly set out for nationally significant infrastructure projects is because the Secretaries of State, or the Secretary of State, who will determine the DCO applications for those, will be expecting to apply or to seek to see biodiversity net gain provided, and there's no need officially therefore to require them to do that. But in practical terms, the national planning statements will be reviewed in time, and we will expect to see biodiversity net gain included in those.
Was there any reason given by government as to why there has to be an absolute obligation with limited exceptions in ordinary planning consents, but if you get a DCO, it isn't imposed as a matter of course?
I don't think there is an official Well, I think the official view is the Secretary of State will make sure that applications will be expected to provide for it, but I don't think I can say any more than that. That's just reporting what.
Yeah, I agree. I agree for what it's worth, David. I think most applicants for DCOs will seek to mirror the requirements, even though strictly speaking it doesn't apply. And of course, you've still got the regard for local plan policy. So it does seem an odd one in some respects, but there may be some rationale for it, who knows. Just a couple of other questions that hopefully we've got just about time to answer. Sarah, a couple for you. Firstly, there's a question in relation to the Green Infrastructure Initiative and how you see that driving the demand for waste management. So I don't know if you want to comment on that.
Well, if we've got more, I think there's more of an indirect relationship between waste management and green infrastructure, which is the sort of expanse of areas really to deliver through the planning system, to provide us with improved environments, to promote well-being, and so on. Hopefully there would be less waste generation because people will feel happier and not want to waste so much. But I think there would obviously be some minor waste related aspects of that, because if you've got more green areas, you're going to have more green areas to maintain and green waste from that. I think probably the biggest impact though will be again in that values point I mentioned about the modelling of the standards that we actually want in order to deliver better environments and greater well-being, where we need leadership to be clearly living the values, and hopefully not see what we've seen as COVID-19 lockdown has been eased, with people going out to enjoy the open countryside and leaving behind piles of waste, which is very sad.
Yes, I mean it was a general point I was going to ask the panel to reflect on, but perhaps this might be something to close with. I was going to bring up the RDF point, but that's a whole nother debate which we probably haven't got time for. But whether or not collectively you think that we will, or the government will, or regulatory bodies will view things differently in a post-COVID world. Clearly, given that we haven't had the traffic on the roads, we've obviously had the improvements with air quality, and actually whether or not we think that will influence in any way how we develop the bill through its next sessions.
I wonder whether it's more likely to drive the sort of net zero initiatives than anything else, rather than the bill, because what it's demonstrated is how quickly matters improve when human activity slows down, and it may encourage greater initiatives in terms of justification for office space and things like that, given what we've learned about remote working over the last few months, and the question about more efficient use of town centres for residential rather than other matters, which are replaced by online equivalents. But I just wonder whether it may drive a greater series of initiatives in that context rather than the bill itself.
I think that direction of travel is perhaps already set when you reflect on the fact that the UK government is adopting this 5% reduction over the Phase 4 EU capping levels for carbon, and the statement that they will go further with a view to accelerating achievement of net zero. So I think that's a very valid point, David, which I'd agree with.
Thanks both.
Yeah.
Any last remarks from others who want to chip in on that reflection?
I think it's probably will have energised some people and some businesses, because they can see the benefits to the environment. I mean, certainly living in Cornwall, when I drive down towards the Tamar Bridge when I'm not cycling, there is usually a haze over Cornwall, and that disappeared during the lockdown. We had wonderfully clear skies, and I could see even further out to Plymouth Sound. So I think that there will be lots of initiatives at an individual level. The question is whether we can harness that energy and the innovation and the creative minds to get a really effective consensus going forward. Because one thing I did meant to say during my presentation was that when the government, the coalition government, was looking at waste management, it was very much not in favour of the kind of regulatory frameworks that business generally liked, because it creates a level playing field, and it had expressed a preference for voluntary measures. I have to say, personal view, 30 years experience, I think the regulatory frameworks are generally vastly more effective than the voluntary measures, which usually take a while before they are then within the EU framework incorporated into law in this country. But there is a need for effective regulation, obviously, rather than burdensome regulation. But effective regulation should drive all of the objectives that we need in order for the environment plan to be delivered. Can I just quickly answer the question on the movement of agricultural slurry and so on from Northern Ireland? Because it's very straightforward. You will still be able to do that. You would have a much bigger problem if you want to move any waste out of Northern Ireland and into Great Britain, because there is going to be a lot of friction there, despite what we hear from others, because of the law.
Thank you, Sarah. Thank you. So I think that's probably a good point for me to say. We can bring things to a close and to thank our panelists and speakers. Yeah, I think on reflection, there's clearly an enormous challenge ahead. The risk of divergence and potential regression, and the complexities that we are going to face in terms of finding our way through the regulations once they do pass into law. I think there are, more challenges ahead than necessarily at the moment things to be feeling comfortable about. So, but a lot of food for thought. So thank you everyone for attending, and I think the sun is still shining, so feel free to go out and enjoy it. But thanks again for joining the webinar, and a recording will be made available, as we said.